Hello, everyone, and thank you so much to the Law Library for having me here today. As Sarah said, my name is Vina Iyer, and I am the Executive Director of the Immigrant Law Center of Minnesota. For me, it's especially special to speak to folks through an event sponsored by the judicial branch, as I started my career here in Minnesota, clerking first in Hennepin County District Court for Judge Susan Burke, and then at the Minnesota Court of Appeals, clerking for then Judge Natalie Hudson, who is now on the Minnesota Supreme Court. Today, we're going to talk about the new day for immigration that we see as a result of the change in administration that occurred in January. I'm going to try to give you a sense of kind of what's happening in immigration law. And as we go through these current developments, I recognize that there are a variety of folks here who probably have a wide variety of sets of bases of knowledge with regard to immigration law. So I will also do my best to make sure that I define key terms that I'm using so that we're all on the same page and everybody's able to follow along. But to that extent, I am in fact the ED of ILCM, and so there are acronyms that I just use as if they are just lingua franca for everyone. So should there be a term that I use or information that I share that's not quite clear, please, of course, use the chat to make sure that I clarify that. And of course, use the chat for any questions that you may have during the conversation today. So first off, I wanted to start by talking about, I think, one of the biggest changes that happened right as the administration changed at the beginning of the year. And that was with regard to what has been called the so-called Muslim ban. And so as you'll recall, one of the signature immigration moves of the Trump administration, right as the administration took office back in 2017, was a prohibition on the entry of nationals from several majority Muslim countries: Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. There were also that ban was challenged in the courts. The first and second iterations of the ban were struck down, but the Supreme Court upheld the third version of the ban, which also included North Korea as well as Venezuela. Eventually, by the last year of the administration in 2020, there were additional countries that were added to the list, so that the total list also included Burma, Eritrea, Kyrgyzstan, Nigeria, and Tanzania as well. And certainly these bans had a significant impact here in Minnesota. As you likely know, we have one of the largest populations of Somalis in the country. We also have one of the largest populations of refugees from Burma, particularly the Karen. And so this travel ban had a significant impact on those populations. Even though there were certain groups that were exempted, there was still a lot of family-based individuals who were waiting for and who even were close to getting family-based visas for example, for lawful permanent residents who weren't able to get them because of the Muslim ban. Fast forward to the very first day of the Biden administration this year, January 20th of 2021. And on that day, President Biden signed a proclamation ending all of the bans that were came within the auspices of the so-called Muslim ban. And so that's very, very important, lifted and made it so that folks who were nationals of these countries could again come into the United States. But as we're going to talk about in a second, the advent of COVID-19 has created other limitations and other restrictions on travel into the United States. So let's get to those COVID-19 travel bans. So under the Trump administration, there were two types of bans that were in place. The first is what I'm calling, the geographic travel bans. So essentially, it restricted the entry of folks and visa issuance to folks who are from a certain number of countries or had been within certain countries which were experiencing high levels of COVID to come into the United States. So that included China, Iran, the European Schengen area, Ireland, the UK, Brazil, and South Africa. So all of there was restrictions that were established based on COVID. In addition, there were also non-geography specific travel bans that were also implemented by the Trump administration. In April 2020, there was a suspension on entry of and visa issuance to permanent immigrants worldwide. So anybody who was seeking lawful permanent residence could not get it, starting in April 2020. And then in June of 2020, there was also suspended entry of visa issuance to certain folks who were going to be coming in on temporary employment visas as well. So those were significant bans that were put in place during the Trump administration. Some are in place still, some aren't. So the geography specific bans continue to be in place. And in fact, India has been added to that geography specific ban because of the significantly high levels of COVID in India right now. And that you've probably heard have been, the numbers were going up significantly over the spring. But the non-geography specific travel bans have been eliminated either because they were rescinded or they were sunset as well. So those COVID-19 bans, we still have them to the extent that they are geography specific. I think we're all watching to see what is going to happen with those as COVID subsides in certain countries over the summer. But of course, we also don't know what is going to happen during the fall. One thing that is also important to note, though, about these COVID-19 travel bans is that folks who are lawful permanent residents of the United States, or for what's commonly known as green cards, are exempt from these provisions. There are also other certain classes of immigrants or migrants who are also exempt, such as individuals who are coming into the country in order to do research or to provide support due to the COVID-19 pandemic. So the travel bans, we will have to see what ends up happening, but I would anticipate that there would be some changes that will be happening shortly. Related to this are changes at the southern border. So at the southern border, there were significant steps that were taken by the Trump administration in order to make it far, far more difficult for individuals to enter the country and seek asylum. Among those actions were what were known as the migrant protection protocols, which resulted in asylum seekers being returned to Mexico to await immigration court hearings. In addition, the transit country asylum ban. So what that meant is that if there were individuals who had crossed through third countries, for example, El Salvador, Guatemala, Honduras, on their way to seek asylum, they were prohibited from seeking asylum in the United States unless they could also prove that they had already sought asylum in those other countries, even if those countries would not have been safe for them. There was also the prompt asylum case review process, which made it so that cases involving asylum had to be adjudicated very, very rapidly. Of course, that can seem positive, but as many of you who may have worked on asylum cases know, it can be very, very complicated to both gather evidence for an asylum case as well as to make the case and then adjudicate the case. And so that prompt asylum case review was very, very concerning in that it really didn't allow time for a full processing of the case. Then there was also the asylum cooperation agreements, and those were agreements with the the triangle countries, Guatemala, El Salvador, and Honduras, which made it so that asylum seekers could be deported to those countries once they had an agreement. And of course, that could have been certain death for a lot of people who were fleeing from violence and persecution in those countries. These these policies are no longer in play. And that's for a couple of reasons. On the one hand, there were several of these programs that were paused because of litigation, even during the Trump administration. There were others that were just simply withdrawn during by the Biden administration. Furthermore, when it comes to the migrant protection protocols, there were still, there's at the beginning of the Biden administration, a number of people who were in Mexico because they had been subject to the migrant protection protocols, but they have been starting to be processed already, and brought into the United States in order to have their hearing. There's another aspect of what's happening on the southern border that specifically relates to COVID-19. And that is what we in immigration are just as a shorthand calling Title 42. So Title 42, Section 265 of the US Code allows this director of the Centers for Disease Control to actually have a role in admission for immigration purposes when there is a significant public health threat of communicable disease. So obviously COVID. So back in 2020, the director of the CDC suspended the admission of individuals who entered the US from Canada or Mexico and would be introduced into a congregate setting. So what does that mean? It meant that people who would be brought into the United States and detained for some reason, because they had entered without inspection, because they were seeking asylum, those were the folks who are being turned around and were told that they could not enter the country. And so because of Title 42. One thing that's problematic here is that, of course, there's no testing being done of anybody who's entering the country. And so it's hard to tell, there's no real evidence for this idea that folks who are coming in who were subject to this rule were any more likely to have COVID or be at risk of COVID than those folks who were entering, for example, with inspection, who were citizens or lawful permanent residents. Now, Title 42 continues to be in effect, though there have been discussions of bringing it down, and there's a significant advocacy being done in order to stop this restriction. One change that the Biden administration has made is that the Biden administration has exempted unaccompanied children from this policy, but it's otherwise been kept in place. And I think it's important to just pause on that for a moment. So unaccompanied children are generally kids who are coming up to the border, trying to come in on their own, usually because they're escaping some kind of persecution in their home countries, perhaps abuse or neglect by their families as well. And so those kids are very, very vulnerable, and they're the groups that we're seeing, frankly, on TV of kids who are coming in, who are in various detention facilities for children. The Biden administration is doing work in order to get those kids released. And I think it's important to note that this is likely to have some impact in Minnesota, certainly some in the Twin Cities, but in particularly in southwestern Minnesota. For those of you who live in the Worthington area or in southwest Minnesota, you know that it is it's a place that has a very, very vibrant immigrant community, and particularly a vibrant immigrant community from Central America. And so as a result, there's a significant number of unaccompanied minors who, in the last wave of unaccompanied minors, about 2017, who came up to Worthington. And we wouldn't be surprised if we see similar increases now. In fact, back in 2017, Nobles County, which is where Worthington is located, had the highest number of unaccompanied minors per capita of any county in the country other than one in Texas. So I think that whenever I share that statistic with folks, they're shocked because they just, it is so surprising to think of that many unaccompanied minors, frankly, up here in Minnesota. But there's a significant number down in Worthington, and I would anticipate that those numbers will increase as more and more children are released from facilities for minors down in Texas and along the border. So we've talked a bit about the border for quite a bit now. Now I'd like to turn to talking about various immigration benefits and how it is that the change in administration has changed how those benefits are, both what benefits are available and how they're being adjudicated. So the first one that I wanted to focus on is deferred action for childhood arrivals. So I'm going to take a quick moment to make sure that folks are familiar with the program, and then I'll go on to talk about where we're at now. DACA is, it's in the news all the time. The program is a program that was created in 2012 by the Obama administration through executive order. And what it does is it provides deferred action and to young people, and then also work authorization. So what's deferred action? The way that I explain deferred action to folks who are not practitioners of immigration law is it's essentially saying we're not, even though you may be somebody who can be deported because you do not have documents, we are going to exercise our prosecutorial discretion not to deport you. In a way, I kind of think about it as being as saying, there's all of these people who you are at the very, very back of the line to be deported. And frankly, you're essentially not even in the line to be deported anymore. We're putting you in kind of a holding pattern for a while. That's what deferred action does. The second thing that folks who have DACA are able to get is employment authorization, so that during the time where you are not subject to work authorization, to deportation, you would be able to get employment authorization. The third thing that's available under DACA is what's called advanced parole. And so that means is that you can seek permission from the government in order to be able to travel for particularly important reasons, even though you don't have, you travel and come back, even though the only protection you have is DACA. One thing that is very, very, very important for everybody to understand is that DACA, it's not a status in itself. It is not lawful permanent resident. It's not a green card. It's not refugee status. It's definitely not citizenship. And as it is now, there is no pathway from DACA to citizenship. And we'll talk a little bit more about potentials for that in a little bit. So that's a big, high-level introduction of DACA. So what happened to DACA under the Trump administration? So back in 2017, pretty early in the administration, the Trump administration attempted to just end DACA wholesale. As a result of a couple of different lawsuits, what ended up happening during the pendency of the case is that the Trump administration was able to succeed in stopping new applications for DACA, but they were forced to adjudicate renewal applications for people who already had DACA. So that was what was happening for about 3 years. So there was about 3 to 4 years where only DACA renewals were being accepted, and people who were starting to become eligible for DACA, so for example, they had attained the age that was necessary, finished the education requirements, they were not able to apply. Then we get to June 18th, 2020, so last year, and the Supreme Court ruled that the Trump administration had improperly ended the DACA program. After that decision, what we expected is that an immediate restart of accepting applications, new applications, as well as continuing to renew folks who had already gotten DACA. That didn't happen. And in fact, what the Trump administration tried to do was to issue a pretty basic memo, not one that actually addressed all of the issues that were cited by the Supreme Court, that were issues that had to be taken into account in order to end DACA. Rather, it was just a kind of overall statement that, hey, we're going to keep things in place in the same place they were effectively even before the Supreme Court decision, other than making a slight change to the frequency of renewals. What ended up happening in December 2020, there was litigation, and a district court said, no. The Supreme Court said you improperly ended the program. That means you got to start accepting applications again. So that's what USCIS did. They started accepting applications, and they indicated that they would continue to issue DACA renewals for 2 years. The issue now is that even in our own office, we've had a number of people who have come to us seeking assistance and who we've helped to apply both initial applications for DACA and renewal. At this juncture, we have 4 years of people who've been waiting to apply for DACA. So there is a significant backlog, 50,000 DACA initial applicants at last check. And even for renewals, where it used to take maybe a couple of months for renewals, now it's taking 4 or 5 months. And so this is a real issue for DACA applicants and for young dreamers. It's definitely an example of where a dream deferred is a dream that just doesn't happen. For these kids, the issue is that they don't have work authorization. They're not able to work. They're not able to start their careers. They're not able to support their families. And so one of the things that is really, really important to us is that there's greater investments in adjudications of DACA applications and other applications for which there are significant backlogs at USCIS. Next, I want to talk a little bit about temporary protected status. So temporary protected status is that it is temporary or supposed to be temporary, and it's a status that is that can be established for folks who are residents of a country that is experiencing some sort of disaster. It could be a humanitarian disaster, it could be an environmental disaster, but it's designated for a certain period of time for folks who might be here in the United States, need protection, need work authorization, to wait it out until the situation improves in their country. Now, the fact of the matter is there's a number of countries for which TPS has been renewed for decades, among them El Salvador, Honduras, other countries, because unfortunately the situations in those countries simply is not improving. And so folks don't have any place to go back to. So that's a high level explanation of what temporary protected status is. And again, what does it provide for people? It provides a temporary status to be able to stay here in the United States. It gives them work authorization, but again, no pathway to citizenship right now. There's no pathway to citizenship for folks with TPS unless they have another basis, for example, for obtaining citizenship. So that could be an employer sponsoring them. It could be that they marry a US citizen and that US citizen sponsors them. So here we've got some information about the countries that currently have temporary protected status. And those countries can change fairly frequently. The Biden administration has extended TPS in several instances. So right now, just recently, they extended TPS for Burma because of the political situation there. Similarly, they just announced, actually, I think 2 days ago, the extension of TPS for Yemen as well. And so these are important. I think what we see is the administration taking steps to more proactively implement TPS. We'd definitely like to see TPS designated for some other countries, for example, such as Cameroon as well. But we will see if that happens. In addition to TPS, there's another status that's similar to TPS, but not exactly TPS. And that's called deferred enforced departure. That also provides for protection from deportation for a particular period of time, as well as work authorization. The difference between TPS and DED is that DED is designated by the president and just the president, whereas TPS is by USCIS. So with regard to DED, we've got a couple of countries that have that. We've got Liberia, as well as Venezuela was also designated by the Trump administration, and that remains. Next, I wanted to talk to you a little bit about another important immigration benefit that was actually enacted right at the end of 2019. And that's the Liberian Refugee and Immigrant Fairness Act, which has a significant impact here in Minnesota because we have one of the largest Liberian populations in the country. and that is particularly up in the northwest suburbs, so Brooklyn Park, Brooklyn Center, really, really large Liberian populations. So to give you a little bit of background about the Liberian community here in the United States and really here in Minnesota, unfortunately, because of the civil wars that happened in Liberia, especially like late 80s, early 1990s, a number of folks came to the United States from Liberia, escaping from the war, from persecution there. Many folks settled here in Minnesota and were able to get TPS. And TPS was renewed and renewed and renewed because of the really difficult situation in Liberia. For years, there have been efforts, obviously, for comprehensive immigration reform and comprehensive immigration pathway to citizenship for folks here in the United States who are either undocumented or have some sort of temporary status, like temporary protected status. Unfortunately, there's no, that hasn't been passed wholesale. But in 2019, but it really is an effort from Jack Reed of Rhode Island and Senator Smith from Minnesota, as well as Representative Dean Phillips. There was significant work to at least try to be able to support and assist the Liberian community who, again, came here escaping persecution, have really become very, very important members of our community, particularly in the healthcare industry. And so they were able to get past what's now known as, what I call LRIFA, the Liberian Refugee and Immigrant Fairness Act. So what that law does is it creates a pathway to citizenship for Liberians, actually regardless of whether they had temporary protected status, but so long as they lived here in the United States on November 2014, and they've been continually present here in the United States, which has a particular meaning under immigration law. Also important, the spouse, child, or unmarried son or daughter of a qualifying Liberian national is also eligible for benefits under LRIFA, regardless of the person's nationality. So just to give you an example, let's say somebody who is Liberian and is eligible for LRIFA ended up marrying somebody who was a citizen of Honduras who was undocumented. That individual would also be eligible for lawful permanent residence through LRIFA. Importantly, in this case, the deadline to apply for benefits under this law was originally at the end of 2020. Because of COVID, Congress extended the deadline to December of this year. So this is an area in which it's it's very, very important to get people to know about this law and to apply under it. And unfortunately, and there's been some really good news coverage of this. Actually, one of our staff members was interviewed for and featured in The World on PRI this last weekend. There just haven't been as many people applying as one would expect. So really, really important to get the word out to this community. Next, I take a drink real quick. But next I wanted to move on after talking a little bit about the different benefits that are available. I wanted to talk a little bit about public charge. So for those of you who may work with low-income or underserved populations, particularly immigrants, this is a term that you may have heard a lot, particularly over the last several years. But for those who haven't heard the term, I want to make sure that everybody is on the same page about what it means, and then talk a little bit about what's going on with public charge right now. So public charge, or the concept of public charge, has been around for over 100 years. It's the notion that if somebody is coming into the United States as an immigrant, i.e. to try to get lawful permanent residence, there is a criteria that the person has to pass to make sure that they will not become a public charge, i.e. they won't become wholly reliant on public benefits. And so it's a test for somebody to get lawful permanent residence or a green card. The public, for years and years and years, the public charge regulations had defined what made somebody a public charge and the receipt of what kind of benefits would deem somebody a public charge. And generally, the rule was that if an individual took cash benefits for themselves, for that individual, that would render them a public charge. But for example, medical benefits would not. The Trump administration proposed changes to the public charge rules in order to make a broader variety of benefits make one subject to public charge. Now, the fact of the matter is that there was only a little, there was definitely a practical effect to this, but the practical effect was fairly limited because if you know anything about immigrants and public benefits, what you know is that most immigrants, most lawful permanent residents, other than refugees and asylees, can't get most public benefits for 5 years. So the fact of the matter is they were already they're not eligible for those benefits. So although, they were not eligible, so there was no way for them to get them. And in that way, the public charge rules and the changes were really had some practical effect for sure, but had the biggest effect of creating kind of creating a chilling effect on folks getting benefits. So one of the things that we found that was very, very sad is folks who were disenrolling their US citizen children from benefits that they were eligible for because they were concerned that they were going to be deemed a public charge. We also saw a lot of families who were not signing up for free lunch through schools because they were afraid that that would make them a public charge. That was never something that would have subjected somebody to being a public charge. So that there was significant litigation around the rule. And in fact, ILCM was a plaintiff in one of those pieces of litigation and went back and forth. There were some wins for the administration, some wins for advocates, but ultimately the Supreme Court allowed the rule to be implemented, and it was the new public charge rule was implemented right in the waning days of the administration. Then what happened is that very soon after the Biden administration took office, they announced that they would no longer defend the rule, the public charge rule as it had been amended by the Trump administration, and reinstated the rule that had been in place since 1999. At this juncture, what does that mean? So as a practical matter, there was a form, this I-944, which was required as a result of the new of the public charge rule under the Trump administration. That's no longer required. However, there is still ongoing litigation around the public charge rule. And specifically what happened is once the Biden administration exited from the litigation, there are states, including Texas, that have sought to come in to intervene and to keep the lawsuit alive and to claim that the Biden administration can't just get rid of the public charge rule as it had been passed under Trump, that rather he has to go through notice and comment rulemaking. So we will see what happens with that litigation and those decisions. So more to come on public charge, probably not the end of the conversation on this issue. Next, I want to talk a little bit about the U visa as well. And that's, I think, really important, particularly for folks here, especially working in the court system. So just to give you some high level background, the U visa is a visa that is available for individuals for folks who are immigrants, who are victims of certain violent and serious crimes. If the individual cooperated in the investigation or prosecution of that crime. So that is it's been available for about 20 years, and it's been of significant assistance to law enforcement and really supportive of victims, because one of the biggest fears that members of the immigrant community have when reporting crimes is that it might lead to their own deportation as a victim. And so the availability of the U visa makes immigrants much more comfortable coming forward to know that they've got some sort of protection available to them if they report the crime and cooperate with law enforcement. Now, the issue with the U visa, as you can see here, is that the current U visa waiting time is more than 5 years. And the reason for that is that there is a cap each year of the number of U visas that can be awarded of 10,000. But sadly, the number of immigrants who are victimized, as well as their families, is much higher than that 10,000 cap. One thing that's and one of the things that's really difficult then is that an individual applies for a U visa, and the way that the system works is that you apply for the U visa. There is a examination several years later to say, hey, do you meet the qualifications such that you can be put on a wait list? And then you're put on a wait list, and then you can get the visa. Now, what the Biden administration is doing is trying to support U visa applicants and survivors of crime during this process where they're waiting for their U visa to be adjudicated. And so what the Biden administration is doing is they've said that once someone applies for the U visa, there's going to be what's called a bona fide application determination. And during that determination, if USCIS finds that the person has a bona fide application, they will be provided with deferred action, so protection from deportation and work authorization while the applicants await final adjudication and a U visa. So that's going to be really, really, really important for folks, because obviously if you don't have work authorization during the time that you're waiting for a visa, you're absolutely vulnerable to exploitation and oftentimes can't support your family. So this is a really, really great benefit that has been added by the administration. The other item I wanted to just highlight is actually a Minnesota specific change. So as you probably saw, a number of bills passed the legislature in the past weeks. One of them was the Public Safety Omnibus Bill. And in that bill, there is what we've been calling the U visa certification bill or provisions. And so what that provision does is it sets deadlines for local law enforcement to make decisions about whether to certify that an individual has been the victim of a crime and has agreed to assist with the investigation or prosecution of the crime. One of the things that's required for the U visa is this certification from law enforcement. And unfortunately, we had seen certain law enforcement units being very, very quick with their determinations, but others taking a very, very long time or not even responding to requests for certification. This law gives some uniformity and will give some closure to applicants, whether it's that, yes, we are going to certify that you were a victim, or no, we're not. And then the victim has their answer. Finally, I wanted to talk a little bit before going on to talking about different legislative proposals, wanted to talk a little bit about enforcement priorities. So the Trump administration ostensibly had a list of priorities. I just saw a question, and so I'll answer that because it was on the U visa. And that's a question about, can the certification be withdrawn? My understanding is yes, the certification could be withdrawn if, for example, the person is no longer cooperating. So moving back to enforcement priorities, the Trump administration prioritized deportation of the following non-citizens: someone who had committed a criminal offense, was at risk to public safety, abused programs, subject to a final order, or arrived at the border without valid documents. Now, that was ostensibly the priorities. But what they added into their priorities was that no class of removable non-citizens was exempt from enforcement. So what happened as a reality was that pretty much any time that ICE intentionally or just happened to come across somebody who was undocumented, everybody was being put into proceedings. There were just so many people who were being put into proceedings, even if they had not committed a crime, had years and years of time here, had US citizen children. So essentially, it was there really were not priorities. It was really ended up being that really anybody was indiscriminately put into proceedings. That is less so the case Now, at this point, those priorities are gone, and we now have the Biden administration's priorities, which are similar to, but not exactly the same as the Obama administration's priorities, which is focused on deportation of folks who are suspected of terrorism, folks who unlawfully entered after November 1st, 2020, or have a threat to public safety because they have been convicted of an aggravated felony or an offense of which an element of active participation was being in a criminal street gang. One thing I do want to note for everybody is that definitely the pose a public threat to public safety issue can feel like it's very, very serious crimes. But one thing I want to note is that an aggravated felony as defined is defined under federal immigration law. And oftentimes it can be something actually non-violent, not, such as actually in some cases shoplifting, depending on what the sentence is, could be considered an aggravated felony. And so it's just, I think, really, really important to note that even though these enforcement priorities are ostensibly supposed to be really focused on public safety, the fact of the matter is that there's instances where they really may address folks who have been convicted of certain drug crimes or and certain nonviolent drug or property crimes as well. One thing that we do see that is very different in the Biden administration too, is that there are changes that are happening with what is happening in the immigration courts. So for 4 years, there were times when continuances weren't granted, where cases were not, for example, put on a status docket when somebody was just waiting, for example, for a U visa. They were going to get it, but they were just waiting for it. That is starting to change. And I think that's really, really positive too, because we're starting to move from during the Trump administration, where every deportation case just kept going. Oftentimes there was a significant waste of resources, especially when the courts knew, hey, this person is going to, for example, be able to get a U visa probably in 6 months. We know that's going to happen. But because the administration, the higher level administration, didn't allow for continuances, et cetera, in many situations, they still had to do a hearing, et cetera, even though it was not necessary. So we're hoping for both greater humanity as well as greater efficiency under the new administration. Next, wanted to, of course, talked a lot about kind of what the policy changes have been, but would be remiss if I didn't talk a little bit about major Supreme Court decisions that came down in immigration this year, and there were many. I would say that it wasn't, unlike the 2019-2020 term when the DACA decision came down. I felt like, DACA was something that I think a lot of people understood and was it has been and will continue to be in the public spotlight, even for folks who are not immigration practitioners. But this term was much more, I think, issues that are really significant more for immigration practitioners. But that said, I do want to make sure to highlight those for folks. So first these are not in the order of when the cases were decided, but rather thinking about where they fit within the immigration process. So Sanchez-Mayorkas versus Mayorkas is really a case that has to do with becoming a lawful permanent resident. And before I talk about the holding of the case, I want to make sure that everybody has one basic understanding. So under immigration law, there's two ways that, not two ways exactly, but I would say it's actually easier to say two places. There are two places that somebody can become a lawful permanent resident or get a green card. Significant number of people are getting it at the consulate abroad. They're in their home country. They are, actually, my mom is a really good example. Now, this was in 1974, but in 1974, my father, the lawful permanent resident, sponsored my mom for a green card. And my mom got approved for the green card at the US Embassy in India, and then it came into the United States with lawful permanent residence. That's one way. So that's called consular processing. The second way that folks become a lawful permanent resident is in the United States through a process called adjustment of status. So that one is my dad. So my dad was here in the United States. He had come in 1969 on a student visa, and then his employer had sponsored him for a green card. He was able to what's called adjust status here in the United States from being a non-immigrant to getting lawful permanent residence. The other thing for you to know is that if you are coming into the country as if you're trying to adjust status here in the United States, you can only do so if you've been lawfully admitted into the country. So my dad, again, very easy example, he came in with an F1 student visa. Frankly, that could have lapsed. He could no longer have it, but because he came in with a visa, he gets to get a green card in the United States. If you don't, let's say you come in without permission, you cannot get a green card here in the United States. You have to go back to consular process in your country. But guess what happens then? Depending on how long you were here in the United States without status, you will then be subject to a 3 or 10-year bar on coming into the country. There are waivers available in certain instances, but not always. And so what happens as a result is there's a lot of people actually here in the United States right now who would be eligible to get a green card, but for the fact they came in without papers and can't leave. They're in a catch-22. They can't stay here and get a green card, and they can't leave to go get their green card because they would be subject to a bar. Sanchez-Mayorkas was addressed that issue with regard to a very specific group of people, those who have temporary protected status. And essentially what the question was in Sanchez-Mayorkas is, well, let's say this individual comes in without a lawful admission. Let's say that somebody came across the border without permission, gets temporary protected status because they're one of the countries that they're from one of the countries that had some kind of humanitarian or other disaster. Is that person eligible for adjustment of status? And the immigration advocates said yes, because the granting of temporary protected status was a lawful admission. The government said, no, 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 it's not a lawful admission. And the Supreme Court sided with the government. The Supreme Court decided that granting temporary protected status is not a lawful admission that allows somebody to adjust status. Next case is Ms. Chavez versus Garland. And first, the thing that you'll need to know for that is that the notice to appear is the document that starts deportation proceeding. It's what says you are a non-citizen. These are or it's supposed to say you are a non-citizen. These are the reasons we think that you're deportable, and you need to show up to court on this time in order to show why you're not. So then a notice to appear. The question in Ms. Chavez versus Garland is, does a notice to appear have to include everything that's required in a notice to appear? Or can it just, can immigration send you one document that says, well, we think you're we think you're a non-citizen. Two months later send something that says, and we think you're deportable for these reasons. And another 4 months later, tell you what your court date is. And the reason that matters, whether it's all in one document or not, is something called the stop time rule. And what happens is the stop time rule is a rule with regard to a very, very, very important remedy to deportation called cancellation of removal. For all of you non-immigration practitioners, this is the basics. Cancellation of removal gets you a green card or allows you to save your green card in deportation proceedings. But guess what? You can only get cancellation of removal if there's if you've gone a certain amount of time in the United States without, in the case of a current lawful permanent resident committing a crime or starting deportation proceedings, or if you're not a lawful permanent resident within a certain amount of time of being in the United States. So the reason it really matters whether that notice of appear has all that information is, does a notice to appear with part of the information trigger the stop time rule, or does it have to have all of it? The Supreme Court actually ruled that it has to have all of it. So that was a very immigrant positive decision. So there's a lot of discussion right now about reopening cases with and also pursuing different remedies and defenses because of this decision. Then in Pareda versus Wilkinson, that's a case in which the court decided that because a non-citizen bears the burden to prove that they are eligible for a relief to deportation, they can't carry that burden if the criminal record is unclear if they were convicted of a crime that disqualifies them from relief. This decision, I think what is really, really important is it's really important for those of you in the audience who are criminal law practitioners, particularly public defenders. As you know, under Padilla versus Kentucky, you have an obligation to make sure that your client is advised of any immigration consequences of a plea or of a plea. And so this is really, really, really important to make sure that both that you're advising properly, but also that you're creating a record properly. And that's why it's very, very important to consult with immigration counsel, qualified immigration counsel, to make sure that the right information is getting into the record. Next, in Garland v. Dye, this is an asylum-related case in which the decision was that a reviewing court cannot find an asylum seeker's testimony credible unless the immigration courts have first found that testimony credible. What had happened there is that the Ninth Circuit had found that if the immigration court had made no decision with regard to credibility, then the assumption was, or should be, that the court found the individual credible. The Supreme Court disagreed with that. Next, in Johnson versus Guzman Chavez, something important, what happened here is that it involved a case in which an individual had been already ordered removed from the United States. Then they are, because of changed circumstances, because they left the country and were already deported and re-entered. But that individual was seeking withholding of removal. That is a very specific defense to deportation if somebody is more likely than not going to experience persecution if they're returned to their home country. And essentially, the question in this case was the standard for bond for individuals who are in that very particular situation. And essentially, the court found that folks are going to be subject to a stricter standard for bond than individuals who are normally in deportation proceedings. And then finally, in US versus Palomar Santiago, the decision there, in that instance, what happened is there was an individual who had been deported based on a DUI. But later on, the Supreme Court found that a DUI was not a deportable offense in that instance. And so he then entered the United States again and sought to collaterally attack his deportation order. But he said he didn't have to prove certain elements because the underlying reason for his deportation was not valid. And the court said, no, you do. You have to prove that you actually, for example, tried to fight your deportation before, that you had appealed, et cetera, even though the basis for your deportation was not. So that's a quick summary of the Supreme Court's decisions. And then finally, I want to talk a little bit about the different proposals that are before Congress right now with regard to immigration. So the first one, the biggest one and the most comprehensive one, is the US Citizenship Act of 2021. That's been presented by the Biden administration. And essentially it creates what I'm describing as two pathways to citizenship, the standard pathway and the shorter pathway. The standard pathway would immediately create a status called lawful prospective immigrant. And that would be for folks who are present since January 1st of 2021, who meet the criteria stated here. Then after 5 years, those individuals would be able to become lawful permanent residents. And then 3 years after that, they would be able to become citizens. The pathway, the shorter pathway, which would be for dreamers, TPS holders, and farm workers, is that those folks would immediately be able to become lawful permanent residents, and then within 3 years be able to get citizenship. So this is the proposal from the Biden administration. It also includes a number of other reforms to the immigration system, including reforms to family-based immigration, eliminating those bars that I talked about earlier, increasing the number of visas available, easier for foreign graduates with STEM degrees to stay here, greater access to green cards for workers in low-wage sectors, other additional humanitarian protections as well. In a lot of ways, I would say the US Citizenship Act seeks to modernize the US immigration system. And I think one of the things that's important to note is that the US immigration system is really built on roots or built on an act, the Immigration and Nationality Act that passed in 1965. So over 50 years ago. So I would say in the same way that our transportation system is really needing needing an overhaul because the structure is obsolete. Same thing is true of our immigration system, and the US Citizenship Act attempts to address that. That law is right now pending in the House and Senate. There hasn't really been much movement on it because what we've really heard from the administration and from others is that really there's been more movement on what we're calling or piecemeal legislation that might create a pathway to citizenship for certain subgroups, which I'll talk about right now. So the act that has gotten the most discussion is the Dream and Promise Act, and that creates a pathway for dreamers that would be immediate conditional or permanent residence, and then after 3 years. Or after you meet the conditions that are required, meet post-secondary requirements, and do military service or work for 3 years, you would become a lawful permanent resident. And then, of course, you'd have to, as is the case now, wait 5 years to become a citizen. For TPS holders and DED recipients, there would be an immediate lawful permanent residence. The Dream and Promise Act has passed the House. The Minnesota delegation did vote along party lines. It has received it's received a hearing in the Senate, but it has not gone to the Senate floor for a vote. Finally, the Farm Worker Modernization Act is another example of one of those piecemeal legislation. It would create a certified agricultural worker status, and then if you meet conditions, would allow somebody to become a lawful permanent resident. It would also allow for agricultural workers to just stay as certified agricultural workers if they did not, in fact, want to stay in the United States. A lot of other changes would also happen to the H-2A process, which is the immigration employment visa process for folks who work on farms and in agriculture. Lots and lots of folks of companies here in Minnesota rely on H-2As. And many of you may have seen some really great reporting in the Star Tribune a couple of weeks ago about the fact that it's been really hard to get H-2As and other types of immigrant visas, and that is the reason that a lot of companies, farms, tourist destinations, et cetera, are having really difficult time addressing labor shortages. This also has passed the House. Again, the Minnesota delegation voted along party lines. So my final pitch to all of you, I know there's a wide variety of folks on the call, some who can and some who cannot do pro bono, but I hope that this presentation piqued your interest in some of the work that we do and some of the ways that you might be able to support and help our immigrant communities here in Minnesota. If you are interested, please feel free to sign up for pro bono opportunities through ILCM. We have a ton of them, and particularly, I'm trying to copy this so that I can put it in the chat for you guys so it's easier to link. Our two main pro bono programs are to assist folks who are dreamers to obtain and renew their status. We have a real need for that. And one of the things I've heard from a lot of folks is that helping with renewals, which frankly take about probably 6 to 7 hours, is a great way to just kind of start getting involved and then later be able to do initial applications, which take more like 15 to 20 hours per case. The other thing that's a wonderful opportunity is assisting lawful permanent residents to become citizens. I can't tell you how amazing it is to talk with clients, to talk with pro bono attorneys who are able to work through that process, and then be able to go together to the River Center, to the district court, to see their client be sworn in. It's an amazing, amazing opportunity. So if you're interested, please, 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 please sign up. We have lots and lots of, we have some great mentors on our staff. We have volunteer attorneys who are mentors as well. So don't worry if what you're saying now is, oh, I'd love to do that, but I don't know immigration law. You don't have to. Our pro bono opportunities are very much signed up for non-practitioners to get involved. I know we're at 1. And I'm so sorry that I did not leave enough room out for questions, but if folks, I'm happy to stay on for a few minutes if folks have questions. But thank you very, very much for having me.